morning, Ms. Lindmark.
Good morning, Your Honor. May it please the Court, my name is Pamela Lindmark. I'm here on behalf of Mr. Acevedo. I would suggest we have before us today a search and seizure case, on the surface a fairly simple one with one basic issue or one primary issue. It's Mr. Acevedo's contention that this case comes down to an analysis of one pair of white, or some would testify black and white Converse sneakers.
Ms. Lindmark, how
Yes,
much
Judge.
time passed between the incident and the defendants being stopped by the police?
It's my understanding it was a fairly short period of time, say some 3 minutes.
3 minutes?
Yes, Your Honor. And it would be our position that despite the fact that it was a temporary period of time, that in and of itself is not enough for reasonable suspicion to have been established and for the police to have justification to have made a stop here.
Certainly, it's a factor. 3 minutes, a few blocks, wearing, one could say, unique sneakers. 2 men. It's nothing? That's none of those things
Well,
add up to a basis to stop someone for a few minutes?
We base our argument, as I think you know, on Commonwealth v. Cheek, which was decided in this court. We would suggest to the court that the fact pattern in this case is quite similar, if not almost the same.
The
and that
time, the time frame was substantially different, though, wasn't it? More than a half an hour, or at least a half an hour in Cheek?
Well, we would suggest that that, again, in and of itself is not enough to have established reasonable suspicion here.
What time of day was this?
The time of day is in the late afternoon.
Okay, is there any evidence as to how many other males were in the vicinity?
The motion judge, in her findings, Your Honor, established, and in fact she seems to have based, and the appeals court as well, much of her decision on the fact that there were not other people on the street at the time that they observed who seemed to generally fit this description. Clearly, they were looking for some individuals who fit the radio broadcast description. However, the motion judge, even in her decision, stated that that description was sparse at best, and that it was difficult for anyone, and especially the police in these circumstances, to positively ID anyone as fitting that description. They appeared to have based their decision to stop these two men largely on the fact that one of them, not Mr. Acevedo, had a pair of sneakers on. There has been testimony that the sneakers were white.
And a pair of unique sneakers.
Well, we're arguing that Converse sneakers are not quite so unique, Your Honor, and not distinguishable.
Converse isn't, but wasn't this a special brand? I mean, they have all these...
Chuck Taylor?
Chuck
Taylor. To be honest,
I don't know what Chuck Taylor is. But
I'm not clear on that myself, Your Honor.
Basketball stuff. Going back decades.
I would argue if they're
young
basketball
Jeff
sneakers,
Female.
that they're not so uncommon, and especially for young men to be wearing.
What about the fact that they were new? Was that broadcast?
Well, one of the police officers, I believe, testified at trial that he observed them to be a pair of white, new-looking sneakers. However, the victim's testimony is that he observed a pair of black Converse sneakers with white tips and white soles, which is quite different from the white Converse sneakers which the police officer testified he observed, and for that reason stopped these two men. And that is why in my initial comments I stated that this case could very well come down to the issue of whether these sneakers were in fact distinctive enough for them to base reasonable suspicion on that.
Well, this doesn't have to be a finding beyond a reasonable doubt. I mean, there's just reasonable suspicion. And to me, I mean, there are so many different brands of sneakers. Just to see Converse sneakers.
Well, Your Honor, I would suggest that Converse sneakers, Chuck Taylor basketball Converse sneakers, are quite common for young men to be wearing.
But it's only probable cause.
And again, our argument is largely based on the decision this court made in Commonwealth versus Cheek. And
Now,
That was a
in Cheek.
three-quarter length goose down jacket, and that's not a brand at all, not even a color. nothing. I mean, everybody wears those jackets.
Again, I would make the argument that the argument made in that case was that that jacket was indistinguishable. Many of the facts in that case, however, I would suggest are stronger than those found in this case to support reasonable suspicion, and yet no reasonable suspicion was found.
Did the police officer say Chuck Taylor sneakers?
I'm not sure, Your Honor.
I think that came out at trial, didn't
It
it?
came out several times with several witnesses.
At trial.
At trial, yes.
I'm not sure
And
it was there
unfortunately, we
before.
don't have the transcript of the hearing itself. We do
Well,
have the judge's findings, and I believe in her findings, she stated that the sneakers were white. And again, at trial, the victim stated they were black with white tips and white soles. Again, confusing the issue and making it harder to say that with several different descriptions of what color and kind of sneakers this man, not Mr. Acevedo, actually had on. It's hard to base a conviction on that.
Well, but we're not basing a conviction on it, and we have to go by the judge's findings of fact, that unless they're clearly, as long as they're warranted by the evidence. And she said one was described as heavier than the other. One wore a black Raiders jacket with a hat under a hat, and the other wore white Converse sneakers. So her finding, and that's what we have to go by, is that the broadcast was one wore white Converse sneakers. So that's what the detectives are looking for. And then they see, according to her, Detective Lyons particularly noted the sneakers. Now, that's a little ambiguous. Except, she says, their clothing was bulky when the police officers saw them, and different from that described, except that one of the men was wearing Converse sneakers. So the facts we have to go on are that the victim said one man was wearing white Converse sneakers, and the detective sees one man wearing Converse sneakers.
But she didn't find they were white Converse sneakers. She only says Converse sneakers.
Right.
And I assume that we are bound by the fact that having been told that they were white, she didn't find they were white.
Well, I have written in my notes respectfully, Your Honor, that on the record, in my brief record, page 16, the motion judge did write white sneakers, but perhaps I mistaken
No,
about
she
that.
said she's describing the description of what was given. One wore a black Raiders jacket with a hat under the hat, and the other wore white Converse sneakers. And then she says, he observed two black males walking on Henley Street. Their clothing was bulky, except that one of the men was wearing Converse sneakers.
But on page 16, your suggestion is when she goes on, she goes, however, one of the men wore white Converse sneakers, which had been mentioned in the broadcast. Is that a finding, in other words?
That's my understanding of it, Your Honor, yes. But if we look at the transcripts, the second volume of the transcripts, I believe on page 10, we have a police officer testifying to black and white, quote-unquote, Chuck Taylor-style Converse sneakers.
And that's at the trial.
And that's at the trial.
Yes, but that doesn't have any bearing on either the evidence at the motion to suppress or the judge's findings, all of which happened long before the trial.
They did, Your Honor, I would
So
agree.
why are you telling us what happened at the trial? It's just not relevant.
Just bringing to the court's attention that there was various and confusing testimony as to these sneakers, and our argument, therefore, is that it's hard to base a finding of reasonable suspicion, which is what appears to be what this hearing came down to, on just those one pair of white
But what
sneakers.
is an officer to do? The officer, he gets a report of this robbery. He goes in the direction where he learns the two men were fleeing. They say that they're fleeing down Hamilton Street in the direction of Sidney Street. And then he sees two men at the intersection of Hamilton and Sidney Street. Do we agree that that's the direction where they fled?
I believe so, Your Honor, yes.
All right. So there are two men in the direction where they fled a few moments after the event, and he sees somebody wearing what appears to be similar sneakers. So what is he supposed to do? What's the officer supposed to do at that time?
Well, he can stop them, surely, and ask them, and they said they could be frisked, and they found nothing.
And they
Right.
found nothing, and they found no weapons, and they found no evidence. And at that point, Your Honor, it would be my suggestion.
First of all, they were frisking them for weapons. They weren't searching them.
Well, that's the argument, but
It's the argument?
That's the finding.
that is
And if they had
finding.
searched them, they would have found the hat, the double hat, and all these other things, and the
And-
wallet, and all the stolen stuff, which they had
And
in
none
their
of,
possession. So obviously they didn't search them, they just did a pat frisk.
They did.
By consent of the defendants, as I understand the finding.
And it's our argument at that point, any further interrogation should have stopped, and the men should have been free to leave. However,
What was the interrogation that took place after that? I thought
Well-
the judge found there was no interrogation.
any further questioning
Well,
should have stopped.
Well, I mean, all that happened was they were detained, and within 5 minutes, the complainant came and identified them, right?
Well, here we get to really the crux of the issue, and it would be my suggestion. The underlying rationale, my understanding of the holding in Commonwealth v. Cheek and the Fourth Amendment to our Constitution is to impose some sort of standard of reasonableness on police officers in the field. How far are they allowed to go when they're questioning individuals? And I would suggest at that point,
Well,
these
they're
men were
detained.
detained. They did not feel free to go. As a result of that detention, they were brought to the scene, they were identified, and all the rest at
No,
this point is
I
history.
agree with you. I'm only quibbling with the questioning part.
Yes,
I
Your
don't
Honor.
think there was any questioning, but maybe I'm wrong.
Now, I'm sorry, the two suspects, they weren't brought to the scene. They were just held there for a few minutes while the victim was brought to them.
The victim was brought to them, and the victim in his testimony stated he was brought to two handcuffed men. And
This is his testimony, I'm sorry, at the trial or the motion to suppress?
at the trial, because,
All right.
again, that's not something we can consider, I guess, but it is interesting to note.
The judge, so the judge, it's the chief talking.
Sorry.
It's
Sorry,
okay,
Your Honor.
the hearing is difficult. She says while awaiting the arrival of the victim, they were not put in restraints. Again, are we confusing what happened at trial?
She did say that, and I made note of that myself, Your Honor. However, the victim did also state, and it's not something for us to consider when we're analyzing the hearing findings, but the victim did state that he ID'd two men in handcuffs. That is in the trial transcripts. And again, our concern here, as has been other courts and this court's concern, that police officers not be given unfettered freedom when they're in the field to violate an individual's right, a right not to be confronted without cause, a right not to be searched without a legitimate reason. We would suggest, and Mr.
Well,
Acevedo...
there's two things here, though. I think we've got to be careful we don't mix them up. Clearly, the police officers they don't even have to have reasonable suspicion to approach and ask the questions.
Correct.
The motion judge ruled that after asking a question or two, the officers asked would they mind if they frisked them. They said no problem. Of course, they had no weapons, so it was apparently no problem. So those two things are not even an issue here. The only issue is that they then asked them to wait, or told them, let's say, that they needed to wait for a few minutes, and that detention is the issue, right? It's the only thing that's the issue here.
It is, Your Honor. And did they have reasonable suspicion to justify such a detention? Clearly, these two men at that point, I would not feel free to go. We would suggest the basis of our argument is that there really was no evidence of suspicious activity that would justify the detention at that point. They had acquiesced. At one point, there was also testimony from one of the officers that they were very cool, calm, and collected. They did not seem nervous. There were no weapons found, and at that point, apparently, no evidence.
But those are just factors to be considered, aren't they?
They are just factors.
Okay.
But when we're considering the picture as a whole, the argument is that the balance under these circumstances should weigh in their favor.
Wouldn't it make sense for the police to have the victim come and look at them so that if they're not the people who committed the offense, they can be released and not be troubled by police activity? Isn't that what our cases say over and over again?
This is the fine line upon which this whole issue is based, Your Honor. And our argument is that really they should not have been subjected to that identification procedure when there was not enough evidence to hold them.
Now, I asked you initially how many minutes after the incident the police stopped the defendant. Do we know how long it took from the time the defendants were stopped before the ID was made.
Approximately 5 minutes was,
So 8 minutes after the incident, the victim was there and made the ID, and either they could have been released if the victim said, these aren't the guys.
the point is here, Your Honor, I believe that it is still a violation of their constitutional rights as a result of them being held for that extra 5 minutes, although it seems like not a lot of time. Mr. Acevedo, here several years later, is still sitting in jail.
No, he's-
Time, I would suggest, is not the important element to consider here, but rather at what point were their constitutional rights violated.
Thank you, Ms. Lindmark.
Thank you.
Ms. Villela?
Good morning, may it please the court. Fawn Bolero Anderson from Middlesex on behalf of the Commonwealth. The defense attorney attempts to boil this whole stop down to one pair of sneakers, but that's not the case at all. In looking at the totality of the circumstances, the facts known to Cambridge Detective Lyons at the time of the stop were sufficient to justify his reasonable suspicion. In this case, Detective Lyons got a radio broadcast of an armed robbery using a gun. There were...
Let me ask you about that. You say that it's reasonable to infer that the broadcast was from the victim. How do we know that? How is there any authority that says that that we can make that inference? You say in your brief, the motion judge appropriately inferred that, quote, given the short time frame between the radio broadcast and the identification at the scene by the victim had been the source of the information broadcast. Is there any authority for making that inference?
Yes, Your Honor. The fact that there was a broadcast put out over the radio for all police to be heard describing the actual assailants, and then the shortness of time between the actual radio broadcast and the stop and the show-up, the follow-up show-up, is enough to find that the radio call was just sufficiently reliable to satisfy the less rigorous requirement necessary for an officer to conduct a threshold inquiry. And as this court found in
Is that a
Ruggiero,
case that you're reading from?
it's actually Ruggiero. It's a 2003 SJC case, which says that you don't have to find reliability at the time of the call. It's just the testimony later at the hearing has to show reliability. Furthermore, the Nilton Costa case also shows that if the 911 caller was identifiable, which in this case he obviously was because he was later involved in the show-up.
Ms. Villela, let me ask you this. I'm looking at Cheek, and I understand there's a time difference, and nobody disputes that. But I'm looking at the decision of the court, and you've got a black male and a black three-quarter length goose jacket.
Correct.
And the court says, and here you have two black males, both in the direction of the crime, but there the court pointed out the Commonwealth presented no evidence to establish that the three-quarter length goose jacket, the sole distinctive physical characteristic of the garment, was somehow unusual or at least uncommon. What do I make of that?
First of all, in that case, the jacket was the only sole distinctive characteristic. In this case, we have other characteristics that are distinctive. But with regard,
I thought what was distinctive. I mean, they don't have a Raiders jacket. They don't have a hat-on hat. So, they have Converse sneakers, white.
they have Converse sneakers. They have two men traveling together, both of whom are black, the only ones in the area who were matching the description. A few blocks away from the crime in a very short time, also consistent, in a location consistent with the direction they were last seen fleeing.
I thought that was the case in Cheek.
In Cheek, we have a black man who was wearing a black jacket walking in a predominantly black neighborhood.
So if there are two black men rather than one black man, that makes them more suspicious?
Not necessarily more suspicious, but it matches the description, and it gives one more level of identification to match up with
Were
the-
these people walking in the direction that was away from the crime scene?
That is correct.
And how about in Cheek? How were they walking?
In Cheek, there was no description on the broadcast as to which direction the assailant had fled.
Wasn't it, it ended up being quite a distance away
A
from
half
the...
a mile from
half a
the
mile.
actual
And this
crime
was just a
scene.
few blocks.
And it was in the vicinity. That's all the court found, not in any particular direction.
What was the difference in time factor between this case and Cheek?
In Cheek, there is no description of the time. It just says sometime later. In this case, it was 3 minutes after the radio broadcast that the defendants were stopped.
Do we know what the time lapse was between when the assault occurred and the radio broadcast?
Not based on the motion judge's findings. I would suggest it was a very short time.
And what's the evidence for that?
The fact that the distance between the actual place where the crime happened and where the call was made is a very short distance. And then the 3 blocks from where the call was made to where they were stopped is also very short. So it makes sense that it was all...
But what was the testimony?
Short time period.
Wasn't there testimony that the victim went someplace to make a phone call?
He did. He went to the Satellite Auto Glass.
And how far away was that from the scene?
The defendants walked with him to that location, and that is where he broke away from them. And the 2 defendants fled from him at that location.
So the reasonable inference is he made the phone call immediately. He was
That is
right in
correct.
front of that store.
That is correct. And he made it at the store because
He had
his
lost his cell
was
phone,
taken
right.
from him. So important
This,
fact,
again, is this at the motion hearing or is this at the trial?
I believe there was some background description of what the call was, what the crime was at the hearing. You have to have a crime in order to stop someone,
No,
reasonable
I
suspicion of
understand.
criminal activity. So I'm assuming there
Well,
was...
actually, you don't.
It's
Actually, you
lawfully.
do not. The police are free to go up to anybody and ask them a question.
But in order to detain them, they need reasonable suspicion of criminal activity. So therefore, I'm assuming that there was testimony about the criminal activity at the motion to
But would it be
suppress.
fair to say that we don't know from the evidence at the motion hearing the time delay between the assault, the time that the victim said that he fled from the assailants, and when the police broadcast occurred?
That is correct. We don't have an exact number based on the judge's findings.
But she does say it's a short time frame between the radio broadcast and the identification, so the
Oh, no,
bookends
no
is a short
question.
time.
No question about that.
That is correct. And
I have a question about something that you say on page 24 of the brief. It says, finally, as the motion judge found and has established a trial, again, is not relevant to this discussion, but the defendants denied any involvement and agreed not only to pat frisk, but also agreed to wait while the victim was brought to the scene. And you cite a transcript from the trial, I guess. Did the motion judge make any finding that the defendant agreed to wait while the victim was brought to the scene?
She just found that they were detained.
Right, so there was no, and that could be crucial when you say in your brief that if they agreed to wait, the whole issue goes away. And you say in your brief they agreed to wait while the victim was brought to the scene.
that is correct. That was the
That was
testimony at
confusing.
trial, and that is not to be considered where it is not found in the motion to suppress judge's
It
findings.
becomes confusing, when we have to read these briefs and you cite, and you make statements based on what happened at trial, and then I think, well, where is that finding? And I look in the judge's.
I agree. Justice
not
Graham
in
got
there.
it right in his footnote 1 of the appeals court decision, where he says we are limited to the judge's findings, and especially in this case where the defendant does not contend that the motion judge's findings were erroneous or misleading in the case.
Yeah, but then we start, his reason for saying that is because we don't have the motion hearing.
That is correct. We don't have the motion to suppress
Is that because
transcripts.
it's been erased or lost or
It was lost.
gone out of state with the stenographer?
The stenographer had a computer problem, crashed. But here, the important factors that distinguish the case from Cheek is the narrow geographic zone in which the defendants were stopped. And as Justice Graham pointed out, they were the only people within that narrow zone that matched the description given over the radio broadcast. Based on that and all the other factors, the fact that there was 2 black men walking together, one heavier than the other, wearing bulky clothing, a few blocks from where they were last seen, in a location consistent with the direction they were seen fleeing, only minutes after the reported crime, and they were the only ones in the area that matched the description, there was reasonable suspicion for Cambridge Detective Lyons to detain them.
Thank you, Ms. Valero.
If there are no further questions, I'll rest in my brief. Thank you.